Mr. Eckhart, you've got a sentencing on Precious Eagland. Sorry about that. I know you're in a hurry.
He's totally open, Judge. I know she told the bailiff she's along with the weather, but I don't think she's sick. She's open.
Good morning. Are you Precious Eagland?
Yes, no.
And are you sick today, Miss Eagland?
Yes.
Okay. Ms. Eagland was previously in court in clause number 25 DCCR 0317, entered plea of guilty to assault on a peace officer. I've received that pre-sentence report. Has everyone had an opportunity to review that report?
Judge.
Yes, Your Honor.
Any additions or corrections?
Just a clarification, Judge. I think when Ms. Eagland reported her version of events to the probation department, she more or less is, denying guilt in what appears to be actually referencing the aggravated assault. It's been her contention all along that she did not commit the offense of aggravated assault.
Right.
And thankfully, Mr. Nichols was willing to let us plead to one or the other. And so she is not a convicted felon. And we are asking the court to accept this because of the fact that she does not deny the plea of guilty that she entered for the assault on a peace officer.
So that's very important, Ms. Eagland. And what Mr. Eckhart is saying, you only pled guilty to the assault on a peace officer, not the other case. But what you said was you weren't guilty in here, which gives me some concern. Is what he's saying correct, that you're taking responsibility for the assault on a peace officer, but not the other?
Yes, Your Honor.
Okay. Anything, Mr. Nichols?
No, Your Honor.
All right, ma'am, I'm going to find that you previously entered your plea of guilty freely and voluntarily. We find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 7 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record.
Yes.
And if you successfully complete the probation at the end, the case will be dismissed. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sentenced to prison anywhere in that range of punishment, which is between 2 years and up to 20 years in prison. Do you understand?
Yes.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. You just need to have a seat here in the courtroom. Probation is going to call you up to her desk when she's ready to go over your paperwork. All right, good luck to you. Thank you.
Thank you. I appreciate you.
And I'll sign that dismissal in clause number 25 DCCR 0318. Do you have that, Kim? Do you have anything up there? No. Okay, thank you. Thank you, sir. Good morning, you're Christopher Street.
Yes, ma'am.
And Mr. Street was previously in court, entered a plea of guilty to the state jail felony offense of theft of property in 24 DCCR 2058. I've received that pre-sentence report. Have you both had an opportunity to review it?
We have, Your Honor. We have no additions or corrections.
I've reviewed it, Your Honor. I'm not.
I guess I'm a little concerned about defendant's version and responsibility. Don't want to
It's,
elaborate.
I mean, they're, even from the state's facts, Judge, I don't think that anyone has any proof that he left with the trailer because he did not leave with the trailer. And that's been my client's issue with the case from the beginning. But I've told him that he was there. He gave whoever left with the trailer
As a part.
access. And so he is an accomplice in this case. He is not the one that took the property, but he did assist them with access. And because of that, under Texas law, that is enough in order to prove his guilt. That coupled with his history, I told him that I thought that if we went to trial, that he likely could have these issues resolved against him and not in his favor. And so with that, we would ask that the court, accept this and move forward. Whatever it's worth, if he could have come up with a full amount of restitution, the state was going to give us a much better result than what we got here. But unfortunately, money for him is just really tight. And so he's unable to come up with those funds. But the $3,000 will be paid today.
All right, so when's the last time you used them? It has. How long's a while?
I want to say 18, but I had some relapses since I got out. But it's been 6 months, you know.
Let's do this. Before I go further, I'm gonna get a drug test done just based on that history, and then we'll see where we go from there. Have a seat in the jury box. Mr. Crenshaw, on Mr. Street. You want to try again on the last time you used methamphetamine?
I've struggled with daily use for a long time, Judge, so
What?
I've struggled with daily use for a long time. It's something I didn't know how to answer that question.
Judge, with his
I'm more
DA status, he's a honorably discharged veteran. I was hoping maybe the court might consider requiring him to get drug treatment through the VA and perhaps consider him for super intensive probation, maybe through drug court.
Sir, stop talking over your lawyer.
Yes, ma'am.
To maybe help him with his addiction issues.
Well, here's where I am. He was already on probation in 2018 for 2 offenses, a burglary of a building and a possession of a controlled substance. Went through the veterans program, including inpatient treatment referral, was revoked on both of those and received prison. The only way I will go along with this is it's going to be safe P going into custody today. We're not taking, there's no reason, number one, on paper for him to really be eligible for probation. Your attorney's done a great job, but if you can't kick the habit, then you're going to get more than just outpatient treatment through the VA. That's already happened. So if, obviously any condition of probation is up to the court anyway, and so we can go forward at this time unless anybody has any reason not to go forward with sentencing.
I'm okay with proceeding now.
Okay, good.
I don't believe my client wants to proceed.
Well, so here's the thing, Mr. Street. The conditions of you've already agreed to probation. So any condition of your probation, outpatient treatment, just like Mr. Crenshaw is asking for, inpatient treatment, which apparently you don't want, those are all actually they're up to me. And so it's not really part of the agreement, and it's not something that I'm going to allow you to withdraw your plea over, because that's up to me. Anytime you're on probation, the conditions are up to the court and probation, what they feel's best. And in your case, if you're showing up to court after having had treatment and after having had 2 felonies already revoked, testing positive for meth, this is what I feel like is best for you and for the community to keep everybody safe. So at this time, in cause number 24, DCCR 2058, I'm going to find that you entered your plea previously freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney and find you guilty of theft of property. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison. I'm going to probate that. I'm actually going to change the length of time to 3 years, which is another condition that is up to the court ultimately. You will be required to pay the $6,000. Did you bring the $3,000 today? Okay, so the $3,000 was to be paid today. So that leaves $3,500 to be paid while you're on probation. As a condition of your probation, what I will do instead of SafeP is order that you enter and successfully complete the substance abuse track of the ISF program. It's still an inpatient in custody program, but it is a shorter one. You will be required to go through the JCDI program when you get out as your aftercare. And so if you do all of that, I don't even know if you realize what a big opportunity this is today. So your case, for all practical purposes here in court, is over if you do everything you're supposed to do. The other side of that is if you don't do everything you're supposed to do, you're going to be back in here and you're looking at the 2-year sentence that you've already agreed to. Do you understand?
Yes.
I'm going to hand you.
Judge, he does have a family. Is there any way that before he turns himself in for ISF, he could have a week or so to get his affairs?
No, not with the criminal history, not showing up testing positive for methamphetamines. Those do not stay in your system that long, which means he has done them very recently. So I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can speak with Mr. Crenshaw. Good luck to you, sir. I hope you take advantage of this.
Thank you, Your Honor.
Thank you. Thank you, Mr. Crenshaw. Mr. Galmore, you have John Foret.
Yes. Good morning, Judge.
Good morning. Good morning, sir. You are John, is it Foret or Foret?
Boy.
Foret. And Mr. Foret has two cases, 25 DCCR 1458, charged with burglary of a building, and then 26 DCCR 0047, charged with criminal mischief. And what is the announcement?
Judge, on the newer case, the criminal mischief, we just repped it last week. We've done our tape request and everything, so I'm expecting that we'll get the videos in here pretty soon, but we'll have to have another court date.
Sure. And those are the same offense dates.
They
So
are.
initially, it looks like there was a new offense after first one, but there was.
Same day.
Okay, just for whatever reason indicted sometime later. Any issues?
No, Judge, just, would the court possibly consider doing a drug test on him this morning, just to kind of see what position we're in?
Yeah, sure. If there's some issues that you want me to check that, I will. Mr. Fort, have a seat in the jury box.
It
We're going
may
to
help
drug
us
test this morning.
towards resolving if we know the result of
Sure.
that.
Mr. Galmore on John Foret, Smallfino. So Mr. Foret tested positive for THC, cocaine, methamphetamines, amphetamines, and benzodiazepine. So obviously, there was some information that Ms. Malfino had that I did not as to why we should test, but there's something going on here. And that's clearly a violation of the bond in both of the cases. I'm going to find that you have violated the bond conditions in cause number 26 DCCR 0047. Raise your bond in that case. Let me see what it's set at. Give me just a second. Okay, thank you. So in 0047, I'm going to raise the bond in that case to $50,000. I'll go over conditions in just a second. And then the first one, do you have that one? Clause number 25 DCCR 1458. Raise the bond in that case to 25,000. Condition in each of those, a bond in each of those cases, if you make those bonds, is that you have a drug patch on at all times. You will have to have a drug patch within 24 hours of your release from custody. They get changed every 2 weeks. If they test positive when you get out, it's a violation, and obviously your bonds will go much higher. Do you understand?
Yeah, so. Okay.
All right, you can go back with the bailiff. That needs to be in paperless. Sometimes it's better.
This one really got confusing too. They're not normally like this.
All right, so you're Brian Morrison.
Yes, ma'am.
And Mr. Galmore is here with Mr. Morrison. Clause number 25 DCCV 1135 is filed. It's like a petition for an expunction and a petition for non-disclosure. I've received an amended petition dated December 2nd for both of those. And the Jefferson County has not filed any opposition. The state of Texas has, and I have their original insert here. Mr. Galmore.
Yes, Judge, the Department of Public Safety filed an objection, so I'm doing a quick prove up. Mr. Morrison, is it true that your name?
Hang on. Would you please raise your right hand?
Yes, ma'am.
Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Go ahead.
Is it true that your name is Brian Allen Morse?
It's not Allison, it's Alan. Alan Morse. Yes, sir.
And your date of birth is 8/13 of 1986.
Yes, sir.
Okay. And was it true that sometime back in around 2007 that you were charged with the offense of drug paraphernalia?
Yes, sir.
And around 2009, you were charged with possession of marijuana?
Yes, sir.
And around 2003, you were charged with theft of property?
Yes, sir.
Okay. And is it true that all three of those offenses, you were never actually convicted or received any type of probation on those cases?
No, sir, I did not.
I apologize. I said that incorrectly.
Here's the amended order.
Yeah, I was reading it wrong.
And I have a petition, amended petition, if that'll help you.
Yes, and this, I think this one I got right here as well. Here, I said that right. I said that. Okay, Judge, I believe that proves up that. And then, is it also true, Mr. Morrison, that you were charged with possession of marijuana?
Where you report?
Sorry. Is it also true that you were charged with theft of service around 2018?
Yes, sir.
And in that case, you did take a deal for deferred probation.
I did, yes.
And in that case, you successfully completed that probation?
Yes, sir.
And you had not been arrested or charged with any offenses during that probation or afterwards? have
No,
you?
sir, I'm not.
Okay. I believe that is sufficient, Your Honor, on
What's the time frame on?
5 years. Yeah, you're right. I should probably.
Is it
put that
after
up.
the end of the probation? when-
It is. And so you started that probation in 2019. I don't have that order. You don't remember the year you finished your probation?
No, sir.
But you finished your probation before February of 2021, correct?
Yes, absolutely.
Yes, that would be 5 years. There's at least been 5 years since the completion of that. And if the court were like, I'll get the deferred order, I have it right here. I can get the dismissal of his deferred to make sure that it falls within that 5-year timeline.
What's the, For myself? What's that clause number?
That cause number is
Probably in here somewhere, but
M321779, which is a misdemeanor.
Yeah, I think.
2 years after probation's over.
2 years.
2 years.
Okay, that makes more sense because you said
I said 5, but
5.
it says 5 on my petition for some reason, but it's 2.
Okay. Okay, all right. So with regard then to the petition for non-disclosure, it appears, well, I guess I'm looking at the answer before I say all that. I'm looking at the answer and
Their answer was before the amended filings.
okay,
So their answer is addressing a petition that we changed
okay,
partially based on their objections.
okay.
Yes.
And since you have filed the amended petition for non-disclosure and expunction, they have not responded with any other.
They have not responded.
Okay, then at this time, I'm going to grant both the non-disclosure and expunction as stated in the amended petitions for both of those, and I'll sign those amended orders.
Thanks, Judge.
Thank you. Good luck to you, sir.
Yes, sir. Thank you so much. No, I just want to let you know, thank you. I'm applying for a job next month. This is going to be.
Good.
Thank you.
Good luck to you, sir.